Hello everybody, very good evening. Hope you all are doing really well. I am CA Supreet Agrawal, your faculty for ACCA AA, AAA and Law subjects. My dear friends, I am quite excited today because today we are going to discuss about one of the most important chapters of your corporate and business law syllabus. My dear friends, this particular lecture is going to be very important for you because this is your first introduction to the work of law. My dear friends, whenever we discuss about law as a subject, a lot of students ask me that how is this going to help us in a further journey, as in is this subject related to some other subject as well? Is this subject going to help us when we will be qualifying as an ACCA? So let me tell you that here we are going to discuss about the global syllabus of your law subject, right? And when we talk about the global syllabus, we are going to discuss a lot of things which are applicable across the globe, and that is why this subject is going to be very important for you. We have already discussed about the exam pattern, the kind of questions that could be asked and the syllabus in the orientation video. So I hope you have seen it. Just in case if you have not seen it, what I am doing is I will be sharing the link of that video with you as well. Okay. But now, my dear friends, what is very important for us to understand over here is that whenever we discuss about law as a subject, we have to go step by step. In total, there are 19 chapters in your law syllabus, and when we talk about these 19 chapters, each chapter is going to bring some new information to you that you will be really amazed to know. But what we have to understand is, along with understanding everything, here we might be required to learn a lot of new things as well, because the exam pattern is 70% MCQs, and that makes it a kind of paper where you can just pass. If you want to just pass, you can do it even via just MCQs, and that is the beauty of this subject. That is, if you want to score really good marks and if you understand everything, then it is going to be very easy for you to score really good marks in this particular subject. And if you want to just pass, even if you understand everything, you can still pass. So that becomes very important for this particular subject. Now my dear friends, let me introduce you to chapter number 1 of this particular subject. Chapter number 1 is essential elements of legal systems. When I talk about this particular chapter, what we are going to cover here, let me introduce you to that. So number one thing that we are going to discuss is we are going to discuss about different types of systems that are followed. It could be economic systems, it could be political systems, it could be legal systems. Then what we are going to discuss here is that since we are understanding the law syllabus, so it is going to be very important for us to understand about different kinds of legal systems. For example, there could be criminal law, there could be civil law, there could be Sharia law, there could be a lot of laws and regulations that we will be learning throughout the syllabus. But this chapter is going to just introduce us to different kinds of laws. Okay, are we going to cover some of the criminal laws as well? No, my dear friends. Here we will be discussing about majorly corporate and business laws only, right? So criminal laws is not part of our subject, but we still have to understand what is criminal law. So I hope you have got good understanding about what the subject is all about. Now let's discuss everything one by one. Okay, what is more important here is that we have to read every line, and it is highly recommended that after attending this lecture, you give a good read to the ACCA study hub also, so that you just quickly revise everything, you just quickly cover all the pointers. Because my dear friends, I will be providing you the summary notes, but what happens is, since there are a lot of MCQs, I personally feel that a good reading always helps you. So these summary notes are prepared keeping in mind the expected questions from this particular chapter as well, and when we will be going for the MCQ solving, you will realize that these notes are really going to help you. So my dear friends, I am going to give you these kind of notes for all chapters. Okay, for all chapters I am going to give you these kind of notes along with the board notes as well. So whatever writing we will be doing, I will be sharing it with you as well. Okay, and then after completion of each chapter, we will be going for the question solving session of that particular chapter as well. Okay, so my dear friends, let's start with chapter number 1 here. When I talk about chapter number 1, the name of chapter number 1 is essential elements of legal systems. Essential elements of legal systems. Okay, so what kind of systems are there? So there is economic systems, there are political systems, and there are legal systems. What are economical systems? What are economical systems? So see, when I talk about economic systems, what it means is that how the system of finance, how the system of production, distribution works in the society. When I talk about political systems, so who has the power to govern the society, as in who has the power to create the laws and regulations to be followed by the countrymen. Then legal systems, this is the course of law, course of justice that is being followed. Okay, so economic systems determine the way in which the society operates financially, that is production cycle, that could be the production cycle, that could be the distribution cycle, all of that. So there are certain countries where production and distribution is being handled generally by the government only, but there could be another countries where there is some decentralization that has been done, right? Some privatization that has been done. Political system determine the way in which the society is governed, determine the way in which the society is governed, that is whether it is a dictatorship, whether it is a republic, whether it is a democracy, what kind of political systems are there. Then legal systems determine the way in which public and private behavior and relationships are regulated within a society. Regulated as in regulated by law, regulated by law, as in that is flow of justice, how justice is delivered. Okay, that is very, very important. I hope this is clear. I hope this is clear. Just in case if you have any doubts, what you can do is you can quickly write to me in the application, or if you are just in case if you are watching this lecture on YouTube, you can write in the comment section as well. I would be happy to answer. Okay, now let's talk about each one of them one by one. So let's talk about the economic systems. Like we discussed, it is the system of production and distribution of materials, right? So the production, distribution and consumption of goods and services in an economy. Production, distribution and consumption. Do you need to remember these words, mug these words up? No. But what you need to understand is when we talk about the economic system, so it is going to talk about the economic affairs. What are economic affairs? It might be related to GDP, that is gross domestic product. It might be related to some of the other aspects which are related to your economics, right? So the production, distribution and consumption of goods and services in an economy. You know, a lot of students make this mistake that whenever there's an MCQ on this, what they do is they just write goods. Okay, if there's a option which includes services, sometimes they forget it. Especially if they are writing the whole answer which is in the descriptive mode, they do not write services. So please make sure that you write services over here. Okay, okay, I hope that is clear. Services you have to write. Now the principles and techniques by which problems of economics are addressed. Now the ways, can you write ways also? Yes. So even if you forget principles and techniques, what you can write is ways. Okay, now the principles governing relationships between institutions, individuals and property. It could be property in the form of assets. That is how the ownership structure is defined. There are certain countries where the ownership of all the properties, all the assets goes to the government, right? But there are certain countries where you can have your ownership as well. Now let's talk about certain types over here. So there could be one economy which is planned or directed economy. Planned or directed economy. Here the production, the distribution, the consumption of goods and services would be in the regulation of government. So the government controls and regulates production, distribution, prices and so on. Are there certain countries like that? Yes, my dear friends, there are certain countries like that. Now a market economy is one based on market forces, the price of goods and services being determined in a free price system set by supply and demand. That is, here the prices are set, the prices, the commodities, the distribution network, everything is set by demand and supply. That is where there would be higher demand, there might be higher prices. Whenever there is lower demand, there might be lower prices as well. Vice versa, there are a lot of economic laws related to it. Our point is to study about the law aspect of it, right? Now most countries today have a mixed economy. This is very important. Most countries today have a mixed economy. So whenever there's a question on which kind of economy is more prevalent these days, you should answer that the mixed economy is more prevalent these days. Okay, I hope this is clear. Okay, in which two extreme examples merge. Now political systems, this was all about economic systems, but sir, only this much? So once we complete these three, this much of content for two more types of systems, we will be done? No, my dear friends. What we have to understand is that our system, our particular syllabus is focused more on the legal aspect of it. So there would be quick discussion on economic systems and political systems. But what we have to understand is that a major discussion would be around the legal systems. So we can finish off the discussion of economic systems in few minutes. We can finish off the discussion of political systems in few minutes. But when we go to the legal system discussion, there we have to invest a major time. Okay, so this lecture would also be majorly invested towards the discussion of legal systems. Okay, now sir, are we going to complete this chapter today? Yes, we are going to complete this chapter today. So sir, we will be completing this chapter, which is one of the 19 chapters of our syllabus today only. Yes, my dear friends, you will be completing it today only. Okay, and what we will try is whenever we come on the lecture, we will generally try to finish off one chapter in each lecture. Okay, there are definitely some chapters where it would take more than one lecture, but generally one lecture for one chapter. Okay, that is the policy that we will be following. Okay, now political system. When I talk about the political system, so the term political systems describes systems of politics and government based on who holds authority within a society, okay, how they acquire it, the influence of government on the economy and the people, and the role of religion in the state. That is, who holds authority, as in whether it is government who holds authority, that is government, or GOVT means government or certain individuals who has the power, okay, within the society. There are certain countries where you will see that the distribution of power is in one end, right? How they acquire it, as in whether it is democracy or what, okay. The influence of government on the economy and the people, influence of government on the economy, as in how powerful is the government, how powerful and how much authority does it have, and the role of religion in the state, that is whether the power is given via religion or whether the power is given via democracy. Okay, examples could be monarchy, republic, democracy, anarchy, right? Now these are the words that we have already discussed in our schools also, generally in the civics also. So just in case if you face any trouble, please feel free to let me know. I would be happy to explain it to you again. Now, separation of powers within constitutional systems. That is how the powers are distributed in our constitution, in the international constitution generally. So my dear friends, there are certain people who create the law, okay, who generally drafts the law. Then there are certain people who has the responsibility to actually make that law implemented at the ground level. And then there is third pillar, which is judiciary generally, which takes care of that if there is any non-compliances, then how they are dealt with, whether appropriate punishments are being given or not, appropriate sentences are being announced or not, right? So let's discuss about it. So the executive branch, this is one, okay, the executive branch of government comprises the head of a state. In India we call them governor also, chief ministers also, and the government organs and institutions. It is responsible for daily administration of the state bureaucracy. Daily administration as in day-to-day implementation, okay, daily administration as in day-to-day implementation, okay. Now, and the implementing of new law formulated by the legislature. Now what is legislature? Sir? Let me tell you what is legislature. This one. So they are the people who create the law. Just like parliament in India. Example, parliament or congress is the branch of government which carries out the function of deciding and passing new laws, and of repealing as in discontinuing, modifying as in altering or changing old ones. That is, they take the responsibility to create newer laws which are required, or to replace or delete the ones which are no longer required. Now, once formulated, new law usually has to be signed off and officially brought into effect by the executive. That is, they can create the law, legislature could create the law, but it is approved by executive only. So generally executive level, example, president. In India, president signs off the new law and they are part of the executive, okay, not legislature. Legislature as in the MPs, right? Now, the judiciary describes the court system. Judiciary, the third pillar, right? Judiciary, the third one, judiciary. The judiciary describes the court system through which legal decisions are made. And enforced. What is the meaning of this word, sir? Enforced. Made, we understand. What is enforced? So see, what happens is, say as the head of my organization, I could create the laws, right? But there would be certain procedures, certain people, certain departments that would actually enforce it, apply it at the ground level. They will communicate that what is required as per the newer laws and how do we apply it, and they will ensure that whether it is applied correctly or not. That is called as enforcing, okay? Enforcing. Implementing, okay? same word as implementing. Okay, now, and also describes the judges and other personnel who keep the system running. Ideally, the judiciary is completely independent of the other two branches of government. Why does it so, sir? See, if judiciary is dependent on the executive level or the legislature level, then there would not be any independence. People would try to interpret the laws to the best judgment, to the best interest of the legislature and executive only. But that is not true. That should not happen. What should happen? That judiciary should work independently and should take the decisions independently only in the national interest, in the interest of the people, in the interest of the nation. So that is why it is very, very important sentence. You should not forget it ever. Okay, this is one of the most important sentences. I hope you have understood till now. Any questions? I hope not. Yes. Now let's come to the third part, and my dear friends, this is going to be the most important for you for your examination as well. Okay, now law. What is law? Please remember this definition. Sir, is it asked in the examination? Generally not, but it could be asked. Okay, law. And as a student of law, you should remember the definition of law at least, right? Law, a set of rules of conduct recognized and applied by a state to members of the community and enforced by the courts. See, number one thing you have to remember is set of rules, right, of conduct recognized and applied by a state to members of the community. Third one, enforced by the courts. That is very, very important. Set of rules recognized and applied by the state. Recognized and applied by the state. That is legislature and executive. To the members of community and enforced by the courts. That is judiciary. I hope this is clear. Yes, I hope this is clear. Now let's move forward. When we discuss about the major legal systems, what we need to understand here is that there are different types of legal systems that are followed. Some could be civil laws, other could be common law, and third one could be religious law. My dear friends, please remember this is legal systems. Okay, you might feel that certain information is repeated, but please go with the flow right now. Okay, then you can ask any of your questions. Now, when I talk about the major legal systems, let's talk about the civil law first. What is civil law, sir? Civil law is related to the breach of contracts, torts. Okay, so it is also called as Roman law, continental European law, or continental law. Do you need to remember this? Yes. Do you need to mug this up? No. You do not necessarily need to write it in the descriptive answers, but what if there is a MCQ question that what else could be called for civil law? So you have to remember it. So the term civil law also refers to non-criminal branch of law. How you can define it? Non-criminal branch of law. How do I say that, sir? See, non-criminal law branch means what? For example, if somebody slaps somebody else, that is a criminal activity, right? It is not at all allowed as per the criminal laws, penal provisions, right? However, if I breach the contract, is it a criminal activity? No. So what happens is, whenever I talk about the civil laws, what should come into your mind is it is a non-criminal, not allowed action. Non-criminal, it is a non-compliance, it is not following the law, but it is non-criminal in nature. That is, if it is a criminal activity, it will come under the criminal law. But if it is related to non-criminal activity, then it is related to the civil law. That should be your approach whenever you explain anything related to civil law or criminal law. I hope this is clear. Let's move forward. Now, non-criminal branch of law within a legal system by which individuals can seek remedies for legal problems arising between them. That is, it could be contracts, it could be family laws, it could be the tort laws. That is, what we have to understand is civil law deals with non-criminal branch and remedies could be provided. Sir, are we going to discuss about the remedies also? Yes. Okay, but not today. Now, common law. Sir, when it is part of this chapter, then why are we not covering it today? It is not part of this chapter, it is part of the further coming chapters. Okay, now common law. What is common law? It is also referred to as English law, English or American law, or judge-made law. Judge-made law, sir. Can judges make law? So no, judges cannot make law, but what judges can do is Judges can set precedents. Precedents, no, precedents. Precedents, precedents. Okay. What is this precedence of? So, for example, if there's some breach of contract between us, okay, and there's an existing case law regarding that if any breach of contract happens in such a case, this has to be compensated. Now, whenever there would be any other case regarding that, no argument would be driven by law. It would be driven by that particular judgment, that earlier also this case has happened, similar case has happened, and the judge either of the similar level or of the higher level have passed this ruling, so you have to abide by it. That is called as common law. That is the judgments, the case laws. That is, certain precedents, certain practices are set by the case laws or the judgments of the previous judges, and that is called as the precedents or the common law. So, in common law, states judicial decisions are the cornerstones of the law. Judicial decisions as in decisions taken by judges. Judicial decisions as in decisions taken by judges. Okay. Now, the judiciary play an important role in identifying, interpreting and applying the law. Now, religious laws. Certain laws are religious based also. So, in some states are recognized state religion operates or plays a part in the legal systems of the country. The most dominant of these in worldwide terms is Islamic law or Sharia law, right? Now, let's talk about the branches of law. When I talk about the branches of law, what we have to discuss here is criminal law. So, civil law again, yes, we have to discuss in a little more detail here. Civil law, then double liability, okay. Now, but sir, there's a detailed discussion of civil law again. I told you, there could be certain repetitions of it. But sir, how will we identify that? How we write answer in the examination? My dear friends, whatever we are discussing about civil law, you can write anything in any of the answers related to civil law. Don't worry about it. Now, let's discuss about it. Law is commonly recognized as having two branches: criminal law and civil law. Criminal law and civil law. Criminal law. Criminal law is the branch of the law through which a state regulates social order by imposing or prohibiting certain forms of behavior. State regulates social order, social well-being also, by imposing or prohibiting. Social order as in what? Social well-being. Imposing or prohibiting. Imposing or prohibiting. Imposing as in what? Imposing as in what? Imposing as in applying. Prohibiting as in restricting certain forms of behavior and imposing penalties on the persons who break the law. Now, this penalty could be in the form of some jail time also, right, and sometimes fines also. In most states, the criminal law is contained in statutes or court. Statutes as in legal provisions or courts defining what conduct will be punished and what penalties are to be imposed. Now, penalties could be in the form of imprisonment for specified or maximum periods of time, say imprisonment for 2 years, 3 years, 5 years, 10 years. Financial penalties could also be there, and there could be mix of both as well. Now, why this line is red, sir? So, see, beyond reasonable doubt is the standard of proof in criminal cases. The burden of proof is on the prosecution. What is prosecution, sir? Whenever there is a court case, there is somebody who fights, who argues from the point of view of state, right? Person arguing from the side of state. Okay. Now, when I talk about beyond reasonable doubt, what is the meaning of it? What is the meaning of this burden of proof and beyond reasonable doubt? See, who will be considered as an offender under the criminal laws, that is decided upon who can be proved as guilty beyond reasonable doubt. So, for example, if somebody claims that this person crashed the car to me, I got injured, and then this person ran away. So, it is a hit and run case, right? Now, if this person could prove, I am just giving you an example, if this person could prove that neither me nor my car was available over there, neither me nor my car was present over there when this accident happened. Now, this is a reasonable doubt. This is not sure. Maybe they are not able to prove, but somebody is their alibi, somebody is their witness who is claiming that this person, this car was not even there. They were with me, right? So, now, in this case, there is a reasonable doubt. So, what needs to be proved to give guilty sentence under criminal laws? Beyond reasonable doubt. Proof beyond reasonable doubt. I hope that is clear. Yes. Now civil law. Now civil law. Civil law. Civil law. Civil law is what? Civil law is the branch of the law which allows individual people or organization to seek remedies against one another through the courts for problems recognized by the law. It could be family law, it could be contract law. The laws of contract and tort are examples of civil law. What are torts other than breach of contract? Civil but other than breach of contract. Civil but other than breach of contract. I hope this is clear. Now, the principal remedy in civil law is money compensation payable by the guilty party to the injured party. Principal remedy is money compensation. What is the difference? In criminal cases there could be prosecution, but in civil cases there is no prosecution. That is no imprisonment. In civil cases. I hope this is clear. Now, on the balance of probabilities is the standard of proof in civil cases. That is based on the probability that could be there. If it could be proved that there is a probability that this person could have committed this offence under the civil law, then they might be required to make certain payment to the person who is getting damaged. The burden of proof is on the claimant as in the person who is claiming the compensation. The person who is claiming the compensation. Okay, to show that the defendant was more likely liable than not liable. That is, there are greater chances. That the person is liable. That is, there are, what they have to prove, the claimant has to prove that there are greater chances that the person is liable than not. That is, the proof in the favor that they are liable is more than the proof that they are not liable. Okay, I hope this is clear. Now, double liability. What is double liability? See, we have understood so many things so far, right? Now let's discuss about what is double liability. What is double liability? What is double liability? So some forms of behavior may raise both criminal and civil liability. Example, fraud. Fraud is a crime, right? Fraud is a criminal activity, whereas it is also a matter of private law. For example, if somebody has defrauded me in my firm, it is one criminal activity that they have done, that they have committed fraud in the course of their employment, but I could also file a case for the purpose of distrust that they have shown, for the purpose of disobedience, negligence that they have shown. That is also civil liability. So there could be certain activities like fraud that could bring up criminal as well as civil charges. Okay, so that is very, very important. The state will seek to punish the offender under the criminal law, and the victim of a fraud may seek to bring civil proceedings against a fraudster for compensation. In most legal systems, the civil and criminal aspects of the case will be considered in separate proceedings in separate courts. Okay. Now, civil law. Again, civil law, sir? Yes, but in a little more detail. Civil code is there. Civil code is there. A codification of private law related to contracts, property, and obligation. That is, there are certain laws which have been created specifically for this. One example in India is the Indian Contract Act. Internationally also there are Contracts Acts. Internationally also there are Sales of Goods Acts. So that is part of this part. Now, role of judiciary in civil law system. Role of judiciary. What is the role of judiciary here? Do they have to interpret the laws, create the laws, pass the case laws? So, civil law judges are legally qualified professionals. They apply and enforce the law. And decide criminal and non-criminal cases. The use of jury is unusual in civil systems. What is jury? Multiple judges. In simple language, I could say multiple people other than judges. So earlier what used to happen was that whenever there used to be a trial, there used to be one judge, there used to be 10-12 people who used to sit as jury. So the case is presented to the jury also decides and helps the judge in making the right judgment. This is not required in case of civil laws. Okay, so use of jury is unusual. Okay. Now, civil judges generally do not interpret or reinterpret the law. Do not generally interpret or reinterpret the law. That is what they do. They just apply on the facts basis. Their function is to apply the law in line with what is says and with the social purpose for which it was created. That is, what they have to do, they have to apply the law in letter as well as in spirits. In letter as in what is written, whether that is applicable 100% or not, and in spirits, that is whether the outcome is as per the legal expectation or not. That is, with what intention, with the intention that the law was created, whether that outcome is being achieved or not. Okay, so that is whether law is followed in letter and in spirit or not. Okay, I hope this is clear. Now, whenever a new situation arises, they consider the historic intention behind the relevant law and apply the law so as to cover the new situation in line with the historic principle. That is, if new situation arises, what they do, they just go back, recheck that with what intention the law was created, and they just try to achieve that intention, achieve that particular outcome. Now, common law. In a common law system, one has not only to look at the legislation made by the parliament, but also in the cases for the judicial statement that actually constitute that common law. That is, we have discussed common law means judgment. So here you do not just need to look at the law, you also have to look at how the state has dealt it, how the senior judges have dealt it, or the judges of the similar level have dealt it in the past. If similar case has happened, how they have dealt it, and you have to pronounce the judgment, you have to announce the judgment based on that. Common law is judge made. Statute law is produced by parliament. This is very important. As parliament is sovereign, it can alter common law by enacting legislation to that end. That is parliament or legislature could alter what? Could alter common law. That is, if some judge have made certain judgments, but if legislature feels that this is not appropriate, what they can do, they can alter it via passing the newer laws. Now, case law. This is the judicial interpretation, explanation and application of law by reference to individual cases. That is done by judiciary, done by judges. The interpretation, explanation, application done by the judges. I hope this is clear. I hope this is clear. I hope this is clear. Yes. I hope this is clear. Now, the legal principle on which the decision rests sets a precedent. Precedent as in what has happened before. The legal principle sets a precedent. Precedent as in what has happened before. Set practice, right? Which must be followed by judges of equal or lower rank dealing with similar situations in the future. That is, if a high court judge has passed certain judgment and it is recognized as a common law, then every high court judge or every district court or sessions court judge has to abide by that particular ruling. Can a Supreme Court judge overrule this? Yes, they can. However, common law states are not regulated exclusively by judge-made law. Case law is supplemented by international treaties also. That is, case law is not a direct form of legislation. It could not happen that only the case laws are referred to take the decision. There are international treaties, there are international transactions, there are international relations also that needs to be kept in mind, international laws that needs to be kept in mind. Okay. Now, the judiciary has an important role in interpreting and applying these laws. Role of judiciary in common law system. Role of judiciary in common law system. So, the duty of a judge in common law system is not to make the law, but to identify, interpret and apply fundamental principles of common law. Not to make the law, but to identify, interpret and apply fundamental principles of common law and to interpret the statute. That is, they have to look for the fundamental issue that the law was trying to address. How is the intention of addressing it? What should be the best course of action that is taken care of here. The general rule is that precedent set by higher courts bind judges in lower courts. Now, points to note. A precedent will, it's not precedent, okay. A precedent will not be binding in a later case if it was wrong, that is, with a lack of proper attention to relevant laws of access. That is, it will not be applicable in case of inconsistent facts. Okay, then a precedent will not apply when the facts of a case are materially different so that it can be distinguished from those before the court. So, different facts. Here, negligence or ignorance is also covered. Then the precedent or ratio of an earlier decision by a lower court may be subsequently overruled in another case decided at a higher level. That is, higher court could overrule. That is, higher court. It's not could, it's higher court could overrule judgments of lower courts. Okay, that is also very important. The earlier judgment is not changed, but the precedent is set aside and will not be followed in future. That is, the judgments that has already been made, that is not changed, but for future it is changed. A higher court may also reverse, overturn a decision of lower court on appeal. The earlier decision is nullified. Okay, that is, sometimes if you are not happy with the decision of the lower court, you can apply to the higher court and then they can nullify the decision given by the lower court. Now let's talk about Sharia law. Okay, Sharia law is an Islamic law. So Sharia law is the law of Islamic religion. Sharia addresses all aspects of life, personal, business and public. In business life, Sharia law prohibits as in does not allow. Sharia law does not allow following. Does not allow following. Okay, number one is riba. Riba as in the making of money from money, that is charging interest, usury. The action or practice of lending money at unreasonably high interest rates, and business activities which exploit or contradict the principles of Islam, that is not at allowed, that is prohibited under the Sharia law. Now there is no trial by jury in Sharia law, no trial by jury is not allowed here. However, the judge is assisted by an advisory council. Advisory council is there of scholars and eminent people who help the judge make the right decision. Okay, and to bring all information to the judge. Now to the attention of the judge. Now they will suggest verdicts which can inform the judge's own reasoning. The members of the advisory council must be capable of independent juristic reasoning and should be of good character. That is very important. Now conflict of laws. Conflict of laws. Whenever we talk about conflict of laws, there could be majorly three conflicts. The key issues are whose courts have jurisdiction, that is whether it is under the jurisdiction of high court, civil court or what. Generally what happens is, say civil laws up to a certain level is given to the civil judges, but civil courts, but a money related transaction up to a certain or above, beyond a certain limit is given to the high courts. Question of facts are generally given to district courts. Question of law is generally given to the apex court, which in India it is Supreme Court, right? Whose laws are to be used, whether international or national, how and where the judgment could be enforced, whether the judgment could be enforced in this country, which country, where the judgment is, where is the jurisdiction. Now let's talk about the international law. Do you need to remember this? Yes, please. Can this be asked in the examination? Yes. Now, international law. When I talk about international law, it by default it means that it is applicable or it might be applicable to multiple nations, right? Multiple nations. So private international law describes different countries' internal mechanism for dealing with international contracts and recognizing foreign judgments, whereas public international law governs the relationship between states and international organizations. So see, describes different countries' internal mechanisms, okay, whereas governs the relationship between states and international organizations. Say treaties are part of the public international law, including international conventions and treaties. This syllabus is concerned with aspects of public international law in the way in which they affect international trade agreements. That is, here we are going to have very little discussion of the private international laws. We are going to discuss more about the public international laws and in the way it affects the business as well. That is something that we are going to discuss. Now we can come to the last heading of the chapter, which is public international law. We can come to the last heading of the chapter, which is public international law. Okay. So a number of international bodies contribute to the formulation and application of international law and cross-border trade regulation. That is, there are number of regulations, number of bodies, number of associations, number of committees that helps in creating this particular law. International trade bodies includes European Union. So do we need to remember it? Please. See, it might not directly be asked in the examination, but you are studying law, so it is very important for you. The Eurasian Economic Community, the Organization of Petroleum Exporting Countries, OPEC, Mercosur, the Southern Common Market of South American countries. Please remember it. Okay. Now, the international regulatory and harmonization bodies which have particular impact on the ACCA Law global syllabus are, this definitely needs to be remembered again. The United Nations, but do you need to remember word by word? No. You should just know that there is something called as UN, there's something called as ICC, there's something called as WTO. Union Nations Commission on International Trade Law, there's International Chamber of Commerce, International Code of Arbitration, World Trade Organization, Organization for Economic Cooperation and Development, International Institute for the Unification of Private Law. Okay. Now, some important pointers. What do we mean by this? Some important pointers. See, there are these many institutions. Every such body, every such institution plays very important roles. But do we need to remember everything? No. What we have to understand and remember is this. So I have taken out certain points from each one of them. WTO, which is World Trade Organization, has the highest explanation, largest explanation, because it is usually asked in the examination as well. So the United Nations. What you need to remember about the United Nations is, although you should give a good read to the study up also, but what you should remember about the United Nations is, the United Nations operates worldwide, best known for peacekeeping and humanitarian assistance. So whenever there is a conflict between two countries, generally on humanitarian grounds, UN gets involved, UN gets it resolved. The UN and its specialized agencies, funds and programs work on a broad range of fundamental issues, including economic and social development. When I talk about the UN Commission on International Trade Law, okay, it issues convention and model laws on aspects of international trade law. Convention and model laws, as in convention as in the agreement that should be made between two trading countries. Model laws as in the structure, the proper format of the laws that could be followed by different countries in a ready-made format. International Chamber of Commerce. So say the country specific Chamber of Commerce is also there. Similarly, International Chamber of Commerce is there, right? So it helps in promote inclusive, sustainable, greener trade, provide rules and standards for international business, and to help companies and states settle international disputes. All of this is done by International Chamber of Commerce. Okay. Now, World Trade Organization. This is important and this is important. These two are sometimes asked in the examination. Now, World Trade Organization. The WTO's main objective is to help trade flow smoothly. Okay. Objective is to help trade flow smoothly. That is, there should be smooth flow of trade, freely, fairly and predictably. It also endeavors to ensure that individuals, companies and governments know what the trade rules are around the world, giving them the confidence that there will be no sudden changes of policy. Them as in the countries. Now, the WTO seeks to achieve these purposes by doing what? Do we need to remember this? Please. WTO's objectives are asked in the MCQs a lot of times. Administering trade agreements, that is, they help in understanding and negotiating the trade agreements terms as well, acting as a forum for trade negotiations, settling trade disputes, reviewing national trade policies, cooperating with other international organizations, and assisting developing countries in trade policy issues through technical assistance and training programs. I'll just give you one example. Okay, if there's a discussion going on between, say, India and US regarding import and export of certain regulations, certain items, okay, and there are certain issues that the India is facing regarding agreeing on this trade agreement with, say, US. Who will help? WTO will help. ICC would help. Okay. Now, however, their areas are quite divided. That is, International Chamber of Commerce sets out the practices, whereas WTO sets out the rules and regulations. Okay, that is the major difference. Now, Organization for Economic Cooperation and Development, OECD. This is also discussed in AA and AAA syllabus as well. So, the aim of the OECD is to help its member countries to achieve sustainable economic growth and employment, and to raise the standard of living in member countries while maintaining financial stability. That is, what is their purpose? Their purpose is to increase the lifestyle or the quality of life in the member countries. Now, the last heading for today, which is International Institute for Unification of Private Law. So, its purpose is to study needs and methods for modernizing, harmonizing and coordinating commercial law as between states and group of states. That is, their main purpose is to do what? Their main purpose is to bring harmonization between different laws and regulations and to bring harmony in the country. Now, my dear friends, this is something that we have covered. This is chapter number 1, essential elements of legal systems, that we have covered. We discussed about the economic systems, political systems, legal systems. We discussed about economic systems in detail, then political systems in detail, then we came for the legal systems. Under this, we discussed about criminal law, civil law, common law, right, and double liability also. Then we discussed about some more aspects of it. Then we discussed about Sharia law. Then we discussed about conflicts of law. Then we discussed about international law. Then we discussed about public international law. And then we closed this discussion. Now, when we will be meeting for the next time, we will be covering chapter number 2. That is an extension of this particular chapter, and you are really going to enjoy it. Now, what I'll suggest is, Please read it carefully once more. Just in case if you have any doubts, please feel free to ask me. You can ask me on the app, you can ask me on the WhatsApp also. Now when we discuss about what you should what you should do further, what you should do is you should go through the ACCA study hub also. Just in case if you have any reference material that you want to refer, you can go through that also. You can ask any doubts to me, be it from the any reference material, but I would strongly suggest just stick to this book and you will cover everything. Okay, don't worry about it. Even if you feel like reading something more, please go through the ACCA study hub. Okay, you can solve the questions also, but we will also be solving certain special questions taken from each chapter. That is how we are going to cover. So all the very best. See you in the next lecture. Thank you.